first case on the docket for Tuesday, December 14th, 2021 is case number 122706, State of Kansas versus Tremayne M. Darkis, Montgomery County. Briefs both sides. We're ready to proceed.
Thank you, Mr. Shima. Council, I would ask that you each come to the podium and one at a time enter your appearances and then return to your council table. Mr. Latta.
Good morning, Madam Chief Justice and your honors. James Latta of the Appellate Defender's Office, representing Tremayne Darkis. Ready for argument.
Good morning, your honors. Michael Duenas, Assistant Attorney General, representing the state, present and ready for argument.
Thank you. Mr. Latta.
May it please the court. Once again, James Latta of the Appellate Defender's Office representing Tremayne Darkis. May I please reserve 3 minutes for rebuttal?
3 minutes is reserved. Thank you, Mr. Latta.
Thank you, your honor. So this case comes before this court on a probation revocation. Mr. Darkis was given 12 months probation. During his probation, he allegedly violated the terms of his probation. And then after the day his probation was to end, his probation officer filed an arrest and detain order to have Mr. Darkis arrested for those violations. Mr. Darkis was then arrested, and the court violated him and remanded him to prison. The Court of Appeals, we argued that the statutes at issue, the probation revocation statute, specifically 223716A, subsection A and E, are in play here. And our argument was that only the court, based on mostly the plain language, but then also having to reconcile a few inconsistencies, only allows the court to initiate the proceedings to revoke a probationer after their probation has ended. And so because that didn't happen in this case, because it was the probation officer, we argued the court lost jurisdiction to revoke Darkis' probation. The Court of Appeals saw things differently, and they gave a different interpretation. They read subsection A and E as your honors know from reading the first sentence of subsection A, there are some time limits. And subsection A says when you can revoke probation, and that's during probation. And then that gives the method to revoke, it gives those the ability to revoke probation to the probation officers and the court. And then when we go down to subsection E, which some people refer to as the savings clause, it gives them the 30-day grace period, which I think everyone agrees the point of that clause is so a probationer can't violate right before they're to end probation and then get away with it. And so the Court of Appeals read the time limitation, read the probation officers from the first subsection A into subsection E. So they said the time limits of subsection A and then the saving clause of subsection E applies to probation officers, even though probation officers are never mentioned in subsection E. And so they got there by saying the only other option was having the probation officers have no time limit at all, because they said the first sentence of subsection A wouldn't apply.
Counsel, the Court of Appeals really does more than that, doesn't it? It not only expands the statutory language as to the actor that can do something within that 30-day period, but also the procedure that can be used, because this was not these officers issuing a warrant the way the court would do it. So it's really it's an expansion at two levels, isn't it?
I agree with that. The two levels of expansion that I see is, first they said that they could add in extra actors, not just the court, but the probation officers. And then the second part, as Your Honor was referring to, was there was no warrant or notice of appear issued. They're basically saying that an arrest and detain order is the same thing as those orders. And so I think where they really got to that was the Gordon case cited in the Court of Appeals opinion, where about 20 years ago this court held that in that case the probationer was alleged to have violated probation during probation, and then in that 30-day saving grace period, the state, the prosecution, filed a motion to revoke. And then this court held that that was okay. And so I think that's where the Court of Appeals got that. Because then some other cases have cited that Gordon case as standing for the proposition that as long as anybody initiates, basically anybody initiates the proceedings before the 30-day saving period ends, then we can move forward.
Do you see the Gordon case as contradicting your argument, or can both live in the same universe?
I do not think they can both live in the same universe. And even though this case did not involve this prosecution filing a motion, I don't think they can live in the same universe that the state can file a motion to revoke and nothing's done by the court within that 30-day saving period to initiate the proceedings. If the state had filed a motion to revoke, in this case, for example, within the 30-day saving period, and then the court issued the warrant or notice to appear, then we'd be okay.
Within the same 30-day period?
Right, yes. Yes, so I do think this court would have to disavow Gordon and say the state cannot, I mean, the state isn't even mentioned in any part of this, the prosecution, that is. So I think this court would have to disavow Gordon and go back to the plain, because I think it's at least clear that the state isn't mentioned. And so we go back, and then to reconcile some of the little bit of the confusion about who all subsection E, I think the plain language of subsection E says the court is the one who files the warrant, the court's the one who files the notice of appear. And the most plain reading is that the probation officers are stuck with the time period listed in the first sentence of subsection A.
Just doesn't seem like a big leap, though, that someone would have to ask the court to use its authority within that 30-day period. That part of Gordon didn't at first bother me. I mean, I understand your argument about they file a motion and the court doesn't do anything for 30 days. But it seems like somebody, for the court to take an action, somebody's got to come to the court and say, hey, did you know that this person on probation is flaunting the rules that you've got and violating those rules? That didn't seem to be out of the question. Do you agree or disagree?
Well, if I'm understanding your question correct, I do, yes, the state, someone has to act or the court would never know to do anything. So what I thought should have happened in this case for it to have been appropriate revocation was, you know, the probation officer comes to the state, says, we have this guy, we need to violate him. And then the state files the motion to revoke, and in the motion they could say, we are in this time period, we need a quick either issuance of warrant or notice to appear from this court. And then if that would have happened, then we would have had an appropriate revocation. But based on the plain language of these statutes and reading them together, I just don't see that a motion to revoke from the state alone would ever be enough to invoke that savings clause.
Refer to the plain language. I take it from that you would say that this is not an ambiguous statute?
I think that that's a tough question because the plain language, for example, says nothing of the prosecution. I don't see how we could read that in, as by example, the Gordon case. But there is some inconsistencies, admittedly, because if we're going to say the time period in the first sentence of subsection A applies to both the court and the probation officers, and not just to the court, because that's what the Court of Appeals found troubling, was if we didn't apply it, then the probation officers could theoretically violate someone at any time. So then I think we have to reconcile those using the plain language of the statutes and saying that subsection E applies only to the court, but the time period of at any time during probation applies to the court and probation officers. And I would cite the rule of lenity for that. I think both interpretations would be at least sensible and have that in favor. Also, the subsection E obviously mentions nothing of probation officers. We know the legislature knew how to do that. They did that in subsection A. And then also just not reading words into subsection E.
Counsel.
In your response, you used the word court in a context that made me think you were talking about the judge. But isn't one definition of court a broader definition that includes all those affiliated officers that make a court function? Not the judge function, but the court itself function.
Sure.
And isn't that what the Gordon court really does, is say that can be ambiguous, and the meaning of that word can be ambiguous, and so they look to the legislative history and find a legislative history that suggests the legislative intent was for the judge and the court services officers to be included within that?
Sure, and I would disagree with that for two reasons. First, when we look just through the statute itself, every time the phrase "the court's" used, I think we can tell they mean the judge. For example, where we talk about, revoking and doing the particularity, I don't think anybody thinks that a probation officer could come up and revoke someone because they're a threat to the public and actually do the revocation themselves. So looking at the way the phrase "the court" has been used throughout this statute, I think they clearly meant the judge. And then another thing I would say is when reading the legislative history in Gordon, they didn't want the probationers to get away with it when they violate right at the end. And I noticed that there was one sentence in there where the judge says "and/or probation officers." And so I focused on that. But also, I don't think it's absurd, at least, to think that the legislature would want to keep it within the court, the judge, a neutral authority to say, after you've already completed your probation, whether we're going to invoke this clause that lets us possibly send you to prison after you've already completed your entire term of probation.
Can a court services officer issue a warrant?
They can't, at least under this statute, they can't.
Where? I'm not seeing it.
Me neither.
Well-
Are we agreeing? Or I'm sorry.
Well, I don't know. I asked if the court services officer could issue a warrant, and I heard you to say yes.
Oh, no, they cannot.
Okay,
Not
so
under this
if a
statute.
court service officer cannot issue a warrant, do you think that informs the meaning of the word "court" in subsection E?
Yes, I think the court is the one who issues the warrant or notice of appear.
But what does "court" mean? That's the question.
Court is referring to the judge. A judge must enter the warrant. And I would refer you back to my answer to Chief Justice
Okay.
on that issue.
Can you clarify for me your argument again on subsection A? I thought you were arguing plain language on A and E, but then I heard you suggest that you need the rule of lenity in subsection A to have the time limitation apply to court service officers?
Well, I think my argument is that the first sentence of subsection A, which has the time limits and which also refers to subsection E, applies to the part where it says subsection E applies only to the court. But the other part of subsection A, where it refers to at any time during probation, that part refers to the court and probation officers. So what I'm saying is it would be hard.
Why is that?
And that's my argument. That's why in subsection E, where we have only the court, so we have to reconcile this and make the statute work, obviously. And so my argument is that the most reasonable interpretation of the statute is to say that the time limit of subsection A applies to both the court and probation officers. And then when we look to subsection E, we see clearly they're referring to the court. Only a judge, they're referring to a judge specifically, and only the judge can issue warrants and issue notice to appear, at least under the statute. So we have to reconcile why it says subsection E in the time limits of subsection A and into only the court. And so my argument is that that's based both on the plain language, where in subsection E it says only the court or the judge can do these things.
But in subsection A, the time limitation court means both court service officer and a judge?
Yes, I think this court would have to read it this way, or else it would be unreasonable to say that a probation, just in what the Court of Appeals said, it would be unreasonable to say that the probation officer has no time limit.
Seems like you can take almost any rule of construction and make this come out one way or the other. So is it the rule of lenity that ends up trumping this in your mind? Or is there some other rule that you think is the one that trumps it? I mean, this is just, I think we could all say this statute's just a mess. So,
I do think the rule of lenity is probably my best argument. And that's because I do think it's sensible and reasonable to say that the time limit obviously has to apply to the court and the probation officer. No one thinks that the probation officers can do this forever. And then to read subsection E as applying only, the reference to subsection E and subsection A applying only to the courts, I think that's where we get the rule of lenity. I don't think I think it's sensible and reasonable to say that based on the plain language subsection E, where it just refers to the court, refers to a judge, refers to what the judge can do, that's a sensible and reasonable interpretation that favors Mr. Darkis. So invoking the rule of lenity gets us there, I hope, gets us over the top. And I see I'm out of time. If your honors have no more questions, I would just
I
ask.
have one question. Have you ever heard of the warrant, quote unquote, issued by the court service officer called an arrest letter rather than a warrant? I mean, they can't issue a warrant, correct?
Not under this statute. I mean, not for purposes of revoking. I don't see any authority in this statute for the probation officer to do anything except arrest a probationer without a warrant or to issue an order to arrest to the other deputies. So my answer is no, they cannot do that. And we would just ask that this court reverse the revocation and discharge Mr. Darkis. Thank you.
Mr. Duenas?
Good morning, Your Honors. Michael Duenas, representing the state. May it please the court. Our brief really has set out our statutory understanding, interpretation, and details, so I won't go through that again. I do think this court, in raising Gordon, ought to rule consistent with Gordon and also with its opinion in the Scolat decision. And so I think that's really the nutshell of our argument, that the subsection E, as the Court of Appeals said, is going to control for both the court and the probation officer in these types of situations.
Do you think a probation officer can issue a warrant?
I don't believe that the statute allows them to issue a warrant. I mean, I do think that.
Isn't subsection E framed entirely in the context of issuing warrants?
It does say, subsection E does say that the court shall have 30 days to issue a warrant for the arrest. So that language is there.
So how could a court service officer act under subsection E?
Well, we would argue that the arrest and detain order in this case effectively function to the same thing.
I understand that and in reality, it basically does.
Right.
But under the statute, the legislature knew how to, in subsection A, the legislature specifically talks about an arrest and detain order. But in subsection E, they don't. Do you think that's meaningful in any way?
I think it's meaningful in laying out the general legislative intent of what what.
Well, it looks to me like, just from reading the statute, that the legislature knew that only a judge could issue a warrant. That's what it looks like to me.
Well, but yet in this court in Gordon found that it was, okay, and the Court of Appeals has sort of gone off that and saying, well, as long as proceedings are initiated, then that's been so.
You have a stare decisis argument. That I understand your primary argument is, hey, Gordon got the statute correct. But if, as a matter of sort of first impression, we disagree with that and think it didn't really get the statute correct, is there any reason why we should still stick with Gordon?
I think you would certainly have to disavow Gordon. As Justice Bowles said, I don't think they could live in the same universe. I think you'd also have to disavow Scolat, which also, the holding at Scolat, the court said revocation may occur after probation ends as long as a warrant, petition, or show cause order has been filed prior to or within 30 days after the expiration of the probationary term. So I think that couldn't stand either, if you were inclined to go that way.
Okay.
In that subsection D or E, it refers to warrant or notice to appear. I think the prior versions of this statute seem to have had other provisions about notice to appear, but the version in effect at the time of this did not. What is that referring to, the arrest letter, the order to pick up that a court services officer can issue, or is that only a court saying notice to appear in court, to basically a show cause order.
So you're referring, so when it says in sub E, to issue a warrant for the arrest or notice to appear for the defendant to answer a charge, I mean, I think that's carrying over the language basically from subsection A. So I'm not sure what the, what the difference, I mean, I'm not familiar with all the different ways that they, like arrest and detain order. I mean, I know an arrest warrant, that wouldn't be precisely an arrest warrant. I think it's just intended to carry over the language to subsection A. But that would be, our argument is pretty straightforward. I think we've made it pretty clearly in the briefs, which is that this court ought not to so narrowly understand court, as you intimated, Chief Justice, to mean just simply the judge, that the intention here obviously was to keep probationers from violating the terms of their probation near the end of their term, and there would be a way to catch those violations even after the probation term has expired, that the court can do that, and the legislature intended for an ISO to be able to do that as well, and so that subsection E would control the entire scheme as far as that goes. And I think you mentioned that the statute, the legislature, we presume they've understood what they were doing when they write those statutes, and that there could be, there's a little play in the joints here in terms of what the actual intention was. But I think that intention was clear. The Gordon court clearly enunciated that by going into the legislative history and looking at that and saying, what were they really after here? And so to include the court or the statements there, that didn't get into the statute in those precise terms, but that seems to be the intent of the legislature. That's what Gordon recognized. That's what panels of the Court of Appeals have recognized. So, to go back to your point, if this court is inclined to say, well, that's all well and good, but we don't agree with that, well, then I think that should be the end of Gordon and those other cases.
Your argument, as I understand it, is that the legislature clearly intended for a court services officer to be able to, quote, issue a warrant for the arrest or a notice to appear, which comes out of subsection E. Can you articulate your clear belief that that was the legislature's intent?
I think what I would argue is that they clearly intended for the court or a court services officer to be able to engage in whatever the proceedings are that they needed to do to bring that person in for some kind of revocation hearing or something after.
That's just not what it says. It says issue a warrant or a notice to appear. And is there any other context in which a court services officer can ever do either of those things?
Issue an arrest warrant?
Or a notice to appear?
I'm not aware of
And
any.
I don't know of any.
I don't know of
instance.
any.
So that would suggest to me that those just aren't those are functions of a duly empowered judge, not an employee of the court. Do you agree with that?
I'm not aware that a court service officer can perform those particular functions. So, the answer would be yes. But beyond that, I don't have anything further. I think, like I said, we've laid it out in our briefs what the argument are. I think they're pretty clear on both sides, and we think this court can affirm what Gordon has said, but and that's the precedential holding at this point. So, and unless there's further questions, I don't have anything to add to it.
Thank you.
Yeah, thank you.
Latta, you reserve 3 minutes.
Unless this course has anything else, I don't believe I have anything further.
I just have a question I probably should have asked the state, but was there a motion to revoke filed, or was it just an arrest based on, just an arrest without a warrant, based on the written or verbal statement?
There was no motion to revoke filed, only the arrest and detain order by the probation officer. Eventually, Mr. Darkis was arrested, and then he came in for a first appearance, and then that's when they set up the time to have the probation revocation hearings.
Okay, and so then Gordon stands for the proposition that subsection E permits the court to exercise jurisdiction to revoke probation when there's a motion to revoke filed within 30 days, right? So that,
Correct.
and your position is that there was no motion to revoke filed.
Yes, in addition, yes.
If there had been a motion to revoke filed, would you have a different position?
No, that's why I think this court needs to disavow Gordon, is because based on the plain language of this, based on the statute, only the court can issue the warrant or notice to appear to invoke that savings clause. So it doesn't matter whether the state filed the motion to revoke or whether we're basing the invocation of that savings clause on the state or the probation officer.
Got it, thanks.
Just real quick, if I understood your answer, you're not saying that the state is not allowed to file a motion and ask the court to perform these,
No,
to
absolutely.
do what subsection E says?
I think that's the appropriate procedure. The
Okay.
state files the motion, the court acts, and then we have an appropriate revocation.
Thank you.
Thank you, Your Honors.
Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement.